Has the accused Delphi murder suspect confessed? The Idaho Murd3r House is going to be destroyed. A murder case has been destroyed because the evidence didn't quite match the prosecutor's theory. Who is watching your kids? And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is CrimeTalk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell so that you receive notifications of when we go live or put up new content. And remember, you can listen to us anytime on any of your favorite podcasting apps. So let's go ahead and open the record for June 29th, 2023. And first on the docket, has the Delphi murder suspect confessed? Well, the Delphi double murder suspect apparently, allegedly, according to the prosecution, has confessed to killing his two alleged victims on at least 5 separate occasions since his arrest, according to newly unsealed court documents that also reveal that they were killed with a sharp object. Now, Richard Allen is accused of killing Libby German and Abby Williams while they were hiking through Indiana's Delphi historic trails on February 13th of 2017. Now, prosecutors allege that Allen has made several phone calls to his wife, Kathy, and his mother while at the Indiana Department of Corrections, in which he admits to killing the two girls. The motion states, and this is a motion to get some records, and they're outlining why they think they should be entitled to it. The motion from the prosecution states, on April 3rd, 2023, Richard M. Allen called his wife, Kathy. In that phone call, Richard Allen admits several times that he killed Abby and Libby. Investigators transcribed the phone call, confirming that Richard Allen admits that he committed the murder of Abigail Williams and Libby German. He admits several times within the phone call that he committed the offenses as charged. His wife, Kathy Allen, then abruptly ends the call and hangs up. Now, the document also contains multiple mentions of instances where Allen was acting different while being locked up, including times where he was eating paper from his attorneys. Now, Richard Allen was wetting down and his paperwork he had received from his attorneys and was eating it, was refusing to eat and refusing to sleep. He would go days without sleep, and he further broke the table that he used to text messages and phone calls. He went from making up to 2 phone calls a day on April 3rd of 2023 to not making any phone calls at all. Well, what have I told you many, many times here over the years, ladies and gentlemen? It's always the defendant's own words that come back and bite them. And in this particular case, I am sure that his attorneys told Mr. Allen not to talk about the facts of the case with anyone other than his attorneys. But they can't refute, they just can't help themselves. The defendants must talk about their case. And one of the best sources of information comes from jail calls, because the people need to tell the people on the outside why they're on the inside. And of course, they either deny it or say, oh man, I really messed up, or what have you. And so we advise clients all the time, do not talk about the facts of the case on the phone. We put it in writing. And guess what? In nearly every homicide case, what do we get? Recordings from phone calls, because they simply download those documents. And it's simple. Back in the day, it was hard work to get phone calls. Now it's like downloading music to your phone. It's that simple. It's all digital. And guess what? You have to document your little PIN identification number saying who's making the phone calls. That's right. Well, some of the released documents also reveal that both of the young girls, Abby and Libby, had wounds caused by a sharp object, and article of clothing were missing from the scene. Now, the filings allege that they also determined that the girls' clothing were missing from the scene, including a pair of underwear and a pair of socks. Libby's iPhone was discovered under her body and contained that 43-second video that helped investigators piece this case together. Now, the Allen County Judge, Francis Gull, has released 118 documents in this case, with only 19 remaining sealed. Yes, great job, Judge. This, the public is entitled to know. Now, details of Allen's other alleged confessions have not been shared. He is said to have broken the tablet he used to make texts and send phone calls, and is not believed to have called or texted anyone in months, probably because attorneys told him to shut your mouth. Oh, you want to go to prison for the rest of your life? Have your own words used against you. Because remember, ladies and gentlemen, that is what they refer to as admission by a party opponent. That's why anything you say can and will be used against you. He's a party to that lawsuit. The people of the state of Indiana versus Richard Allen. Anything he says can and will be used against him. Not just what is said to the police. People just never seem to realize that. Well, as we know, investigators also searched the home of Richard Allen and several outbuildings, including a shed and Richard Allen's car, looking for firearms and knives. The police also scoured the home for electronic devices, clothing, and a specific cell phone. Law enforcement recovered numerous items, including boots, multiple knives and sweatshirts, multiple cell phones, an iPod, a hard drive laptop, and other electronics. Now, the affidavit released from November 2022 shows that an unspent .40 caliber round was found between the teenagers' bodies, and it was later linked to Allen's Sig Sauer Model P226 firearm through forensic evidence. Prosecutors believe the gun links Allen directly to the case after forensics determined a bullet found next to the girl's body had cycled through the gun. Needless to say, Allen's defense attorneys are contesting that evidence from the Indiana State Police lab, and they have also argued that Mr. Allen has been under great physical and mental duress because of his incarceration, arguing that any admissions of guilt must be unreliable. Prosecutors have countered that, saying that Allen's behavior has changed dramatically since his admissions made on April 3rd, probably because his attorney told him to shut up. And the court documents have also revealed that he has not made a single phone call since that admission and has undergone a psychiatric evaluation. And let's not forget, when Mr. Allen was first interviewed in regards to this case back in 2017, he told officers that he had been on the scene at the time of the murders to watch the fish. Authorities then chose to re-interview him on the matter back in October of 2020. Well, the reason they had to go back and re-interview him was because an FBI contractor misfiled the interview where he put himself at the scene. So that's why they went back in 2022. And Mr. Allen has also admitted that he had clothing similar to that guy known as the bridge guy that was captured in that video. Now, Kathy Allen also confirmed to police that her husband owned several firearms and knives, as well as the blue Carhartt jacket similar to the one worn by bridge guy. Now, obviously, he's pled not guilty, and we'll give him the presumption of innocence. Remember, the defense has also said that they have the wrong guy, that the affidavit is flimsy, and they expected more. Well, Mr. Allen is being held without bail, and he is scheduled for trial on January 8th of 2024. Next on the docket, little Brian Kohberger update. The home where the 4 University of Idaho students were murdered last year is set to be demolished. Now, it's not exactly sure what date it's going to be demolished, but any personal items that are still there have been removed, and any belongings of the 2 residents who were not injured during the quadruple slaying. I always have mixed emotions about this. We don't tear down every house that has ever had a homicide in it. Not sure why the university wants to tear down this one, other than they think it's going to cause too much pain and grief. Or they're going to put up another house where people walk by and say, hey, that's the house that they built where they tore down where those quadruple murders were. Or if they put a park in there, it's going to constantly remind people of the quadruple murder. I just don't get it. I don't get it. Hey, but it's private property. People can do with it what they want. Next on the docket, murder charges dismissed because soil samples and cell phone records didn't quite add up to the prosecutor's theory of the case. So a Texas man accused of killing a 13-year-old by the name of Haley Dunn has been released from jail. The murder charges against him have been withdrawn as of this time. Now, after spending 2 years behind bars, Sean Casey Atkins was released from the Mitchell County jail on Tuesday. The court documents revealed that the state requires, quote, further investigation, end quote, before proceeding with the case to a jury trial. Apparently, law enforcement received numerous tips and leads during the investigation following Haley's disappearance. However, many of those tips and leads well, were apparently not properly vetted, investigated, or cleared, according to the motion. Now, Haley was last seen back in December of 2010 at her Colorado City home. Her body was found near Lake J.B. Thomas in Scurry County 3 years later. Atkins was the former boyfriend of Haley's mother, Billy Dunn, and was arrested back in 2021 on the murder charges. But let's take a look as to what exactly didn't quite turn out correctly. Now, obviously, the prosecutors, when they're filing a motion to dismiss, has some explaining to do to the court because you've kept somebody in custody for 2 years and now you're just dropping the case. So the prosecutor says, hey, obviously our duty here is not to convict, but to seek justice. That's one of the ethical rules for prosecutors. But the prosecutors state in their motion, the state's duty to see that justice is done, and the prosecution in this case believes that further investigation is needed for the state to proceed to trial. To be clear, the prosecution views Sean Casey Atkins as the primary suspect in the Haley Dunn murder on or about December 27, 2010. However, additional work must be done before the case can be proven beyond a reasonable doubt. The district attorneys note that this is a complex circumstantial case. The state of Texas has spent the last year collecting, organizing, and reviewing the voluminous amounts of discovery in this case. Moreover, the state has met with and interviewed nearly 50 witnesses associated with this case. Through the course of its preparation and reviewing the discovery currently available, it is clear that additional time is needed to fully investigate the veracity of all of the issues that have arisen during the course of this case and during trial preparation. A summary of some, but not all, is included. Let's see what they have to say. The prosecutors have said that they provided to the defendant through his attorney a 16-page comprehensive Brady notice detailing exculpatory, impeachment, and mitigating evidence in this case. The Brady notice explains in greater detail the information contained in the motion. And the investigation of Haley Dunn's murder spanned over a decade and involved an array of law enforcement agencies, including but not limited to the Colorado City Police Department, the Mitchell County Sheriff's Office, and the detectives of the Texas Department of Public Safety, Texas Rangers, and the FBI. The motion states, one of the critical pieces of evidence for the state involved a soil analysis conducted by a soil expert for the state of Texas. During the initial investigation surrounding Haley Dunn's disappearance, law enforcement collected a pair of work boots belonging to the defendant. Haley Dunn's remains were discovered in Scurry County. This expert, using a testing method known as near-infrared spectrometry, or NIRS, in her analysis, and using NIRS, the expert concluded the soil samples obtained from the defendant's boots had a high degree of chemical similarity with soil samples collected from the remains sites. Prior to the expert conducting a soil analysis, the same soil samples had been sent to the FBI crime lab in Quantico, Virginia. Using methodology peer-reviewed and recognized by the geological forensic science community, the FBI forensic scientists determined that the soil samples from the defendant's boots did not match the soil samples collected near Haley Dunn's remains. Upon meeting with the FBI and preparing for trial and considering the expert report from the state of Texas and the FBI, they all learned that the NIRS is not a testing methodology, easy for me to say, sanctioned by the forensic science community for soil analysis. Oh, I think they referred to that as junk science. Then we have the forensic anthropology report. Haley Dunn's remains were recovered on March of 2013 and sent to the University of North Texas, where they were analyzed by a forensic anthropologist. The forensic anthropologist observed blunt force injuries to Haley Dunn's skull and determined that the injuries were perimortem, meaning that they were inflicted at or time the near of the death. These injuries are catastrophic and likely would have resulted in significant bleeding. While multiple searches of the house were conducted by law enforcement, the state of Texas is not aware of any forensic testing that was done in the house of the immediate aftermath of Haley's disappearance. In addition, multiple searches of the vehicles at issue in this case, as well as the locations of Haley Dunn's remains, were conducted by law enforcement. As a result of those searches, some evidence was collected that was never tested. Before this case proceeds to trial, the evidence should be tested. Another piece of evidence was their cell phone tower data. The cell phone tower data was analyzed by a cell phone analyst with the FBI's Cellular Analyst Survey Team, or CAST team. Among other things, the records show that on December 27th of 2010, Haley Dunn's cell phone sent an outgoing text message at 2:16 p.m. and another at 2:27 p.m. During this same time, the defendant's cell connected to a cell tower in Big Springs, Texas at 1:53 and 2:40 p.m. The records reveal that the defendant placed an outgoing call at 2:56 p.m. on December 27th that connected to a cell tower along I-20 east of Big Spring but west of Colorado City. The records also show that 1 minute later, an incoming call to Haley Dunn's cell phone connected to a cell phone in Colorado City, Texas. These two facts taken together, while not conclusive, lend support to the proposition that Haley Dunn may have been alive prior to 12:57 p.m. on December 27th of 2010. The evening of December 26th, Haley Dunn's brother spent the night with two friends. He returned home on December 27th at approximately 5 p.m. Upon his arrival, he saw and spoke with the defendant. Haley Dunn was not there. At approximately 6 p.m., the defendant left the home to pick up Haley Dunn's mother from work in Snyder, Texas. The defendant was not alone again until the following morning. Viewing the evidence collectively, if Haley was alive when the defendant arrived back at the house, he would have been alone with Haley Dunn for most approximately 2 hours, from approximately 3 p.m. to 5 p.m. This means that the defendant would have had to kill her, clean up any blood and other incriminating evidence in the home, and hidden her body in a relatively short amount of time. While this is not impossible, it presents additional challenges given the preceding issues. So, obviously, you want the police to get the correct person, but you don't want them to accuse and maybe wrongfully convict someone who is innocent. So, hats off to the prosecutor doing their job. Clearly, they've become aware of the problems with their case. And you notice sometimes that doesn't happen until they start doing actual trial preparation, where they actually have to be able to show what their theory is. Remember, how many times have we said this? It doesn't matter what you think. It doesn't matter what you believe. It only matters what you can prove. Next on the docket, who is watching your children? If you have children in daycare, just make sure you know who's watching them. Good little plug for CrimeTalkSearch.com, if I must say so myself. Chaos erupted at a Massachusetts courtroom during the first court appearance of a daycare worker accused of sending photos of naked children to a trans politician. Lindsay Groves appeared in court on Wednesday to face accusations that she took nude images of children ages 3 to 5 at the Creative Minds Early Learning Center, Tynesboro, which is about 35 miles northwest of Boston. Now, prosecutors allege that the New Hampshire resident took the photos in a private bathroom during breaks before nap time and texted them to someone with whom she was previously in an intimate relationship. And guess what? They shared approximately 2,500 texts with each other. The investigation into Groves also led to the arrest of Stacey Lawton, who is believed to be the first transgender person elected to the state legislature in the nation. She is charged with distributing child pornography. Several parents were present during the first court appearance at the courthouse in Boston, with several of them yelling at her that she was being led away from the courtroom at the end of the hearing. Now, according to the affidavit, Groves allegedly used the routine bathroom breaks for the children, such as diaper pull-up changes prior to nap time, to take multiple photos of prepubescent children in a private bathroom and then sent the photos to the former intimate partner. Yes, prepubescent, ladies and gentlemen, that is the definition of pedophile. Now, these texts allegedly included discussions of the explicit images when they were being transferred, and they also included at least 4 sexually explicit images of children between the ages of 2, 3, and 5. Now, Graves is charged with sexual exploitation of children and distribution of child pornography. The daycare center has been shut down and is cooperating with the police. Who's watching your kids, ladies and gentlemen? Who's watching your kids? please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, our dumb criminal of the day. A Florida man has been arrested after he allegedly stole a police car and was later spotting the police car while wearing the police officer's hat. Please meet Joshua Lee Marlowe. Reportedly stole the Miami police car outside of the Jackson Memorial Hospital. Now, the officer was parked outside of the hospital, actually dropping off another person. Then Marlowe was caught on video walking up to the car, getting in the car, and driving away. And about 30 minutes later, it was discovered that he was driving the car with the police officer's hat on. Little insult to injury. Needless to say, Mr. Marlowe was arrested and found to have a suspended driver's license. How dare he? No, I think he has bigger problems than the driving license charge. He's been charged with grand theft of a law enforcement car, burglary, and driving with the suspended license. If I was his attorney, I would plead that down to driving with a suspended license right now, take credit for time served. I don't think they're going to go for that. Anyway, that's all we have for today. Have to run to court. Thanks for watching. We'll see you next time.